Salutations, and welcome to another captivating episode of Idea Defense 101. How's it going? It's board game night here at the lab, and our selection tonight is an American classic with rich ties to intellectual property.
I want to put another hotel on Baltic Avenue.
You can only put one hotel on a property.
Aha! Income tax. I'll buy it.
You can't buy income tax. You just pay it. The game of Monopoly is a great illustration of how different forms of intellectual property can come together to protect multiple aspects of your creation.
Let's start with patents. Charles Darrow was granted a patent in December 1935 for his board game apparatus. The claims of this patent covered the layout of the board and the pieces, which at the time were new. Various rules of the game were also covered in conjunction with how those pieces worked.
But the thing about a patent is, the monopoly, no pun intended, only lasts for a limited time. The patent for this game would have expired at some point in the 1950s, so the basics of the board layout and the game rules have been in the public domain for decades. Go to jail? That's the 5th time already.
But that was not the only avenue of protection. The name of the game itself, Monopoly, is a federally registered trademark. That means others cannot use the name or another confusingly similar name for their own board game. So when you see derivative games using the name Monopoly or Somethingopoly, they have likely taken a license. And other logos of the game may be protected as well, like Rich Uncle Pennybags.
My hero.
The good news for trademarks is the protection can be continuous, as long as you use the marks and periodically renew your registration. Free parking.
That'll be $50.
You can't charge me. It's free. It's in the name. Anyone have a file or a hacksaw?
There's also copyrights. The game's artwork, such as on the board or in individual pieces, constitutes subject matter that can lend itself to copyright protection. So long as the copyright lasts, which can be a very long time these days, others are prevented from using the same board artwork or piece shapes as the original.
So while someone today could make a game with the same rules, they would at least be prevented from using the same or similar names, logos, and artwork. This can help maintain differentiation as the original, even if the patent protection has ended. Remember to talk with your attorney about the different avenues of protection for your ideas. Hey, where's voiceover guy? He's supposed to be the banker.
And what happened to all the money?
You're sure this cash is real?
Absolutely. Now hit me.
But we're playing gin.
I said hit me.